So the ATF has suffered a huge loss in the lawsuit against their regulation of force reset triggers, but the ATF has not given up just yet. So let's talk about what the ATF is doing against force reset triggers. Also, I want to ask you guys for a huge favor. A lot of you are aware that we have a podcast available. Here on the YouTube channel, we have about like 570,000 subscribers. We get, tons of views here on the YouTube channel. I would love to create a two-way movement on the podcast side of things, potentially get some big guests, maybe people even outside of the two-way world. One of the goals is to reach about 50,000 downloads per episode. I'll tell you guys that we are far off from that, but I know with this community that we have here on YouTube, if even just a fraction of you guys go over and support the audio side, we will create a huge movement and it will really help the podcast and just the audio side. So again, if you're interested, I leave links down below in the description section, the pinned comment. But regardless, thank you guys so much for all of your support. As I mentioned in the intro, in this video, I have an update for you on the battle against the ATF and their new restrictions on force reset triggers. You may recall that a recent order blocked the ATF in their current attacks on force reset triggers, and that's a case called NAGR v. Garland. We recently received an order from Judge Reed O'Connor, which enjoins the ATF from enforcing their FRT rules against plaintiffs in that case, along with NAGR and also their members. Well, the ATF has not given up on the FRT issue at all, and has decided to take this issue up to the Fifth Circuit Court of Appeals in the hope that the Fifth Circuit Court of Appeals rules in their favor and overturns the decision by Judge O'Connor. Now, for this specific case, I need to lay some groundwork because this has been a multiple year saga between the ATF and then also rare breed triggers. Back in July of 2021, the ATF sent out a cease and desist letter to rare breed triggers. In the letter, the ATF claimed that in their eyes, the rare breed FRT-15 force reset trigger meets the NFA and GCA's definition of a machine gun. Because of this, the ATF claimed that the triggers were subject to the registration, taxation, and possession restrictions like actual machine guns are. So they decided to interpret the NFA and GCA in a way that the triggers on their own were actually deemed to be machine guns. Also, the ATF claimed that the possession of those triggers outside of the GCA and NFA's restrictions would subject a bunch of law-abiding people to potential criminal penalties. Now, in response to that, originally there was a lawsuit filed by Rare Breed Triggers, and that was in the Middle District of Florida, but ultimately that case was thrown out by the court there because there was some filing errors by Rare Breed Triggers and also the ATF, and so the case was just completely thrown out of that original case filed in Florida. Now, recently, Rare Breed Triggers partnered with NAGR to file a lawsuit against the ATF in the Northern District of Texas, and the case is currently in the hands of Judge Reed O'Connor, who is also responsible for a lot of wins that we've got against the ATF, including cases against the pistol brace rule, the unfinished frames and receivers rule, and just a lot of other cases, which are resulting directly from Judge O'Connor in his review of these ATF actions. Now, while all this was going on in Texas, there was a different lawsuit, which was in fact filed by the US government against Rare Breed Triggers. And again, that was in the Eastern District of New York. Ultimately, on review, this federal district court in New York ruled in favor of the government, the ATF, and granted their preliminary injunction against Rare Breed Triggers and then also Rare Breed Firearms. That injunction in New York prevents Rare Breed Triggers from engaging in any sales of the various FRTs and other devices. However, we also had Judge O'Connor in a federal district court in Texas who originally granted NAGR and Rare Breed their request for a TRO, but now he has issued a preliminary injunction against the ATF's regulation of FRTs. Judge O'Connor, in reaching his big decision against the ATF, used the en banc decision in Cargill, which struck down the ATF's interpretation of bump stocks as machine guns. The Cargill case is very relevant also for what the ATF is doing here with FRTs because they're using the same type of logic that they use against bump stocks, also against FRTs. Now, to win a preliminary injunction, you have to show that there is a substantial likelihood of success on the merits, that irreparable harm will be suffered, that the balance of hardships is in your favor, and it's also in the public's best interest that this harm is prevented. Judge O'Connor, in reviewing those factors, found that a preliminary injunction must be granted in this case. In his order, he ruled that plaintiffs are likely to succeed on the merits. Here, plaintiffs contend that the ATF's regulation broadening the machine gun definition is an arbitrary and capricious expansion of the agency's authority. Plaintiffs are likely correct. Accordingly, the court concludes that plaintiffs have carried their burden at this stage to show that the expanded definition of machine gun likely exceeds the scope of the ATF's statutory authority. Therefore, plaintiffs have satisfied arguably the most important of the 4 factors. Now, Judge O'Connor goes on to point out that the Fifth Circuit's en banc panel's decision in Cargill also controls in this case. He also rejected the government's argument that he should adopt some of the language and rationale that was used in the decision out of New York. He just completely rejected that, said he does not have to adhere to what the New York District Court said on the similar case dealing with FRTs. Instead, he is controlled by what the Fifth Circuit en banc panel said in Cargill. Judge O'Connor also goes on in the order to state that there is very clearly irreparable harm because there is a credible threat of prosecution by the ATF because of their interpretation of FRTs. He points out that the ATF has already come to the homes of the plaintiffs here in this case and other individuals in relation to FRTs and the possession of those items. Based on that, Judge O'Connor granted a limited injunction in favor of the named plaintiffs along with NAGR and their members. Judge O'Connor did deny a request for a national injunction, but instead gave protection to the named plaintiffs along with NAGR and their members. He also added in a section clarifying that his order in no way would override the New York decision, that the New York decision enjoined the specific company here, Rare Breed Triggers, from selling and marketing the FRTs. His decision did not affect that at all. Instead, it was more targeted towards the individuals, not the company. Now, in response to the granting of this limited preliminary injunction, which was huge and did a big number on preventing the ATF from enforcing this rule, the ATF sought to stay the injunction. They sought a stay from Judge O'Connor so that they could appeal the decision up to the Fifth Circuit. This is a traditional federal rules process. Traditionally, what happens is the ATF, the government here, whoever loses, first has to seek a stay from the lower court. And so that's what they decided to do. And they are going to appeal this, and we're going to talk about that here in just a second. But on review, Judge O'Connor decided to deny that stay. He stated that, as before, defendant's sky is falling arguments do not overcome the serious harms plaintiffs face. Defendant's arguments are premised entirely on a presumption that FRTs are machine guns, a conclusion already twice rejected. For the third time in this litigation, defendants offer speculative, conclusory statements about the proposed danger of FRTs that are not supported by their own facts. And the realities discussed above cast doubt on the parade of horribles that defendants say will occur if the injunction remains in force pending appeal. Defendants do not carry the burden to show how their equities now weigh in their favor, nor do defendants show how the public interest will be served by a stay pending appeal. To the contrary, the preliminary injunction broadly maintains the status quo of general non-enforcement against law-abiding citizens and serves the public's interest by preventing defendants, the ATF, from enforcing their likely unlawful definition of machine gun. For these reasons, the final 2 factors also weigh against a stay. So the ATF stay request was denied by Judge O'Connor. But the ATF will never take a loss, so they have decided to file an appeal up to the Fifth Circuit Court of Appeals, seeking review and a reversal of that preliminary injunction, which was issued by Judge O'Connor. So the FRT issue is by no means finished. They are also asking, in the meantime, for the Fifth Circuit Court of Appeals to grant a stay on the injunction so that they can continue to enforce the FRT rule. So now we will have an FRT appeal in the Fifth Circuit Court of Appeals, and we'll have to wait to see how the Fifth Circuit decides to deal with this stay, if they're going to agree with Judge O'Connor, if they are also going to deny that stay, and it's going to be very interesting to see what happens going forward because the Fifth Circuit has been very pro 2A. They have denied a variety of stays. They denied some stays and some requests in the Vanderstock Frames and Receivers case, but ultimately what ended up happening is the ATF decided to go to the Supreme Court and they got relief from the Supreme Court. So it's going to be very interesting and telling to see what happens in this case. Now, I do still want to warn everybody to be careful if you're watching this video. If you are thinking about FRTs, maybe if you have possession of them, just be careful. The ATF has been very aggressive when it comes to the possession and sale of FRTs. This injunction is limited at this time to only the plaintiffs in that case, and then also NAGR and their members. But what we have seen, especially in reaction to this case in this decision, is that the ATF has still contacted some individuals. Someone was contacted in Virginia about their possession of FRTs. Of course, if you're ever contacted by law enforcement, do not talk to them. Contact an attorney. And also, if you're an NAGR member, contact NAGR. They help that individual in Virginia. But again, just be cautious. The ATF is still trying to enforce this rule, even despite this decision. And again, this is not a permanent decision. This is just a preliminary injunction. So a lot could change even in this case. But of course, if we get any more information, if anything else develops, I will let you all know. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But regardless, thank you guys so much for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.